Then everything changed, as it seemed, with tremendous speed. And it wasn't long before you, in the Court of Appeal, were giving some of those sensational judgments about the discretionary actions of ministers, where the whole subject of abuse of power suddenly became prominent, and the judges discovered, I think very much under your leadership, that they had the power to review the reasonableness of what ministers and tribunals decided in matters of discretion, and that they were able to provide legal remedies against them if they abused their powers.
Well, now I remember that perfectly well. There was a very important case called Padfield's case, where the Minister of Agriculture claimed he had a discretion and he needn't act on a Committee of Investigations report. He wasn't going to have any report at all. And it went before the courts. And I remember Lord Parker, in the first instance, he said we ought to be able to interfere with this. And he spoke to me about the Court of Appeal, and I thought we ought to be able to interfere. But my two colleagues said no. So Lord Parker and I were rather disappointed. We talked about it privately. We were very disappointed about this. But thank goodness it went to the House of Lords. And the House of Lords, well, certainly on that occasion, did a very good job of work. They declared, I think this is following our old cases, mark you, that if the minister failed to exercise his discretion rightly in this sense, if he took the wrong things into account, or didn't think the proper things into account, we could interfere, or if he was actuated by some improper motive. In this case, he wanted to get the thing away from being discussed in Parliament. If he went on wrong motives of that kind, we said the courts could interfere, or the House of Lords said, and that, if I may say so, was a great triumph for Lord Parker and me, because then the House of Lords had affirmed what we'd been saying. We should be able to interfere with this discretion, if it was abused, of ministers and any of their underlings.
So that was an occasion, in the words of one of your later cases, when the House of Lords sent a relief force over the hill to rescue you.
Yes, well, of course, that was followed, and of course we were able to follow that in other cases about ministers, you know. Do you remember that case we had about the licenses for television? And the minister wanted to increase the charges every year from £12 to £18 a year. And some of the subscribers said, oh, well, that's all right. We'll take out our new license at £12 a week before the year comes to an end. The minister didn't, so we got it for £12 instead of 18. The minister didn't like that. And he said, I'll revoke those licenses for those chaps who tried to get round it in this way. But that was entirely improper. And a solicitor in the City of London, a very important firm called Congreve, he brought the case before us, and we said the minister wasn't going to have power to revoke licenses like this. He was not going to use his so-called discretional powers in this case to revoke, and we interfered with him. No appeal to the laws, thank goodness. And then, of course, do you remember Freddie Laker and his Skytrain? Well, everything was set for Freddie Laker. He got the Civil Aviation Authority to give him a license here. He got the American Civil Aviation Board to give him a license there. It was awaiting on the word of the minister. Yeah, the minister, in effect, didn't give him the go ahead because this is really what he wanted to support the monopoly of the British Airways Board or whatever it was then. So he wouldn't give Freddie Laker the go-ahead for that. And it was said he had some sort of odd prerogative, some treaty-making prerogative or something where he could interfere with things of this kind. Well, that came before Mr. Justice McCatter first, and then it became before us, and we said the minister was quite wrong. He hadn't got a prerogative of this kind. We weren't going to allow him to abuse his prerogative, and we sort of said that Freddie Laker was entitled to have his Skytrain fly. and the minister abided by our decision, and so Freddie Laker flew his sky train and brought all the fares down, as you know. But that was entirely because by that time we were ready to interfere with ministers who abused their powers or exceeded their powers, showing, and again, no appeal to the Lords. We were following good precedents.
All those cases that you mentioned, Lord Denning, in that last group, were notable because they were decisions of ministers taken personally at the top administrative level in situations where the Act of Parliament appeared to give the minister a completely unfettered discretion. And of course it's one of the problems that the law's been up against all along, that the drafting of statutes is dictated usually by government departments, and they're put through Parliament on a three-line whip, and MPs have very little say in what the statute actually provides. It then usually provides that the minister can do more or less exactly what he likes by giving him what Crown Counsel usually call unfettered discretion. And the great landmark which you and Lord Parker and the House of Lords set up in the Padfield case was surely that they repudiated the whole idea of unfettered discretion and said that even though the minister may do something, or even though he may act as he thinks fit, it still means that he's got to act properly and lawfully and in accordance with the true intention of the statute which gave him that apparently unlimited power.
Yes, that has been the controversy all the time between those who argued for the government and the Crown and us, if I may say so, the ordinary judges who felt, well, this is going much too far. And that was always the argument. The statute gives the minister discretion. If it shall appear to the minister, if the minister shall think this or that, then he can do this or that. Apparently, on the very words, the minister's dictum or his decision was binding, and the Crown lawyers always argued, oh, he's got a discretion given to him by Parliament, an unfettered discretion. That is what we, the judges in those days, revolted about. We had old cases to get back to. I went back to Lord Mansfield, I went back to Lord Green and so on. And although a discretion is given, it's got to be a discretion exercised. This is how we brought it in, exercised in accordance with the law. If the discretion is exercised unreasonably, it goes beyond the law. If it's used for an ulterior motive, again it's beyond the law. In one way or another, we were able to upset discretion after discretion of ministers where he claimed it was unfettered.
I suppose in all this series of cases, the Tameside case was the one that aroused the strongest political reactions.
Well, yes. Now, which government was it? Which local authority?
Well, if I remember rightly, it was the Conservative local government which was given orders by the Labour central government in London that it ought to reverse the policy for the schools, which had been started by the previous Labour government in Tameside, to abolish the grammar schools and go in for a wholesale policy of comprehensive schools. Then the minister, under the Education Act, had a power which said that if he was satisfied that a local educational authority was acting or proposing to act unreasonably, he could give them orders.
That's right.
And he said, of course, I'm fully satisfied. I believe that it's quite wrong to preserve these grammar schools. And he thought that merely because it said if he was satisfied, therefore he could issue orders.
That brings it back to my mind. I remember now there's this great controversy whether schools should go comprehensive or not. And the policy of the Labour government and Labour people of the day was comprehensive government, schools. Conservatives were saying no. And in Tameside, the Conservative local government, when they got in, to say, no, we're not going comprehensive. We prefer to keep our grammar schools and the like. And the Labour minister said, oh, but I don't think that's right. I'm going to interfere with your decision. The question is whether the courts could upset, or whether he could upset, the Conservative local government. And we then did, and the House of Lords affirmed it. They said that the courts could interfere with the minister's decision if it was utterly unreasonable, as it was for him to interfere in the circumstances of that case.
Well, yes. Well, the question was whether he was entitled to be satisfied that the local government
Right.
were being unreasonable.
Yeah, that's right.
And it was really what you might call a textbook case of what unreasonable means in its legal meaning. Because it doesn't just mean what the minister thinks in his own personal opinion.
He's got
is
to be
unreasonable.
satisfied that they were unreasonable, and no one could say that they were unreasonable.
It's got to be so unreasonable that no reasonable authority could do it.
That's right.
So that when you had what was after all purely a difference of political opinion between Conservative and Labour, and lots of reasonable Conservatives thought one thing, and lots of reasonable Labour supporters thought the opposite. Nobody was being unreasonable. Now, it seemed, therefore, that the minister had no business to be satisfied that
No
the
minister
local
was
government-
satisfied that the local council were being unreasonable.
Do you think that's a right test for the courts to apply for unreasonableness, this very objective test and this very broad test, that nobody ought to be able to reach a decision like that?
Oh, I certainly agree. In fact, that's the way the law is developed. No one is allowed to take a decision which is so unreasonable that a reasonable person wouldn't come to it. That's really rather longhand. No person is allowed to be utterly unreasonable.
I'm afraid it's often been held that learned judges have done exactly that. But nevertheless, that seems to be the test. Then, of course, there was the Laker Airways case, which you said something about, and that had this very interesting prerogative angle to it. You mentioned that in terms which seemed to suggest that you didn't think very much of the argument. But I believe you held in your judgment that the powers given by the royal prerogative, like the power to make treaties and the power to declare war and all that kind of thing, the power to confer peerages, the power to incorporate corporations, that all those powers which the common law gives to the Crown, which of course are purely discretionary, that they ought to be subject to the control of the courts, just like any others.
Yes, I think I quoted some old authorities for that. For in the old days, the Crown or the King, by virtue of his prerogative, claimed it couldn't be questioned in the courts at all. If he said it was by virtue of his prerogative, it couldn't be questioned. And that was prayed in aid in some circumstances in this Laker case. Well, I think we said, and I brought some old authorities forward, John Locke and the like, I said, well, that's not right. The extent of the prerogative can be determined by the courts, and the judges could say whether it was exceeded or not. In this case, the minister had exceeded any bounds of any prerogative that he had.
That really was, the prerogative part of it, was under the Bermuda Agreement.
Yes.
Whereby Laker couldn't get landing rights in the United States under the Bermuda Agreement unless he was designated by the British government
That's right.
as an approved carrier
That's right.
to have landing rights. So the British government thought that even if they weren't entitled to stop him at the British end, which of course was another of the points that you held in the Court of Appeal then, they were entitled to stop him at the American end
By not designating.
by not designating him. And you'd think that that was something the long arm of the courts could not reach according to previous ideas, because that's something in the outside world of foreign affairs, where the Crown is normally given a free hand to commit acts of state and all that kind of thing, to make treaties, to revoke treaties, to enter into any sort of engagement that it likes. And the remarkable feature of that part of the Laker case seemed to me that you were reaching out even into the outside world, which has previously thought to lie beyond the reach of the
in
law.
order to do justice, we're ready to do that, as I would do it. Because he'd got the approval of the Civil Aviation Authority here and of the authorities over there. And the underlying motive was to keep the monopoly of the British Airways and to knock out Freddie Laker.
And I think your colleagues, perhaps if I might put it that way, keeping their feet firmly on the ground, held that they could discover an implied prohibition in the civil aviation case, which said that there always ought to be at least one independent carrier allowed to compete with British Airways. And of course it was because the minister disregarded that you set aside his direction.
In other words, a rather narrower ground of decision than
on the narrower ground. But then they thought, well, you could perfectly well construe it as prohibiting any action, direct or indirect, calculated to frustrate the policy laid down by Parliament. Would you agree with that too?
Yes, that's equally a tenable view, you see. Rather on the lines of the other cases which we've been discussing.
Do you think now the courts may have gone too far?
No. In fact, I wanted to interfere more sometimes, and I've been told to be wrong, because I think it's still important that the courts should uphold, this is important, the rule of law. And quite often the courts have said we aren't going to interfere still with the discretion of the minister. They will interfere, they say, if it's so unreasonable, no unreasonable man can. That's I quite agree. I'd like it a bit further. The courts can interfere if they're unreasonable. Just that, I should like to say. Or if they're wrong in law, or if they're unreasonable. In other words, I should like to go rather further than some of the courts, even the House of Lords, have been doing.